Hi, everyone. Welcome to our panel to discuss institutional investor activity in global securities, class, and collective actions. As Andrew said, my name is Steve Cirami. In my 25-year career in the class action industry, I've had a number of different roles, from a class action litigator to a claims administrator, and now head up our class action support at Broadridge for broker-dealers, asset managers, and other institutional investors. I'm excited to moderate this panel over the next 2 days, and you already heard it with the first two panels. You're going to hear a lot of interesting developments in class action laws, trends, and our panel is going to handle some of those same issues, but with a little bit differently, looking at it through the lens of the institutional investor and how it's impacting them and their customers. Specifically, we're going to explore the role of the institutional investor in class actions and collective actions, along with the evolving demands, risks, and challenges that they face. We have an excellent group of panelists, all of whom spent their careers in the class action industry and offer a wide variety of perspectives. We've got a plaintiff's attorney, a claims administrator, and a colleague of mine who represents institutional investors and talks to them every day about these issues. With that brief overview, I'd like each of you to give a little bit more color of your background and experience. Mark, would you like to start?
Thanks very much. Good morning, everybody. Last year it was a very good-looking audience. This year I think it's even better. So well done. And in fact, in terms of the audience, I do have a quick question, because there is an amazing array of sponsors. I think they've done a great job at organizing this event. Everybody that I've spoken to is incredibly interesting. But I do wonder how many potential plaintiffs or claimants there are in the room, and how many are more funders or associated with the sponsors. So I know everybody is a potential claimant in a consumer class action, so you're all included there. But in a securities class action, you need to be an investor with a significant amount at stake, probably. So are there any investors here today? Okay, and then if you could put your hands up if you're not affiliated with a sponsor. I'd be interested to know that. Okay, so a few, but essentially we're all in the choir, and I'm going to do a bit of preaching nonetheless. My name is Mark Solomon. I'm a securities litigator in the United States. I've lived in the United States since 1985, except for a year when I came back to the UK to qualify as a barrister. I'm a managing partner at Robbins Geller Rudman Dowd. We have around 200 lawyers, and we are the largest firm in the practice, in the arena, and I live in San Diego.
Great. Hi, everyone. I'm Christy Cannon. I'm a colleague of Steve Cirami's, and I too have been in the class action space for my whole career. So I guess going on around nearly 30 years now. Started off litigating class actions, working primarily at a plaintiff's law firm, litigating with firms like Robbins Geller. Also worked for a few years at a defense law firm where I defended securities and antitrust class actions, so I kind of had both of those perspectives. Actually, it was about 6 months after I joined the bar that the Private Securities Litigation Reform Act passed in the U.S., so certainly for purposes of our panel today, that was a really big driver of the participation of institutional investors in class actions, and I know everybody on this panel has a really rich background in that way. I also worked with Steve at the Garden City Group, where we did do the claims administration on a lot of these very large global settlements, and have been at Broadridge for the last 2.5 years, where I work with Steve and with my colleague Tripp, who's also here from London, to service institutional investors, and that can be a wide array of different institutions, for their portfolio monitoring and claims filing in class actions for the antitrust and securities cases. So it's really great to be here. It's nice to see everyone.
Morning, all. My name is Pete Crudo. I am with Computershare or Gelardi, depending what side of the Atlantic you're standing on. Like Steve and Christy, I went to law school to work in claims administration, apparently. I've been doing it for some time. I wasn't not my entirety of my career. Being from San Francisco, I had to work in a startup for a bit. You know, I've been fortunate to work on some of the largest settlements that have occurred. Enron, which had over 100 eligible security types. AOL Time Warner, which was a $2.2 billion settlement and had the Black-Scholes model driving some of its damages calculations. And currently, both Fortis and Steinhoff here in Europe under the relatively new regime. So it's been interesting to see the evolution. It's the first few panels were very interesting as well, and I'm excited to hear what goes on the next couple of days.
Thank you all. So as I mentioned, we're here to really talk about the institutional investor in these cases. We've got a few topics that each of our panelists is going to address, but please feel free to ask questions. We'd love to keep this interactive and address any other issues that we might not cover in our beginning remarks. So with that background, Mark, could you kick us off and talk about the institutional investor's role in the early parts of securities class actions or collective actions?
Sure. And just to, like it's an exam question, I'll just go through the heading a little bit. What's an institutional investor? Well, it's a non-human being, but I wouldn't say a family trust is really an institutional investor. We're really talking about pension funds largely in my practice, but you could be any type of institutional investor to have a claim. What is a global securities class action? I'm not sure I even agree that there is such a thing other than in Australia, where in the BHP case recently, the Australian courts agreed that global class actions, securities class actions, were viable in Australia. In other words, BHP shareholders who purchased their shares on the UK exchange, as well as those who purchased on the Australian exchange, can bring claims. And therefore, that would be a global class action. In the States, as you just heard, Morrison versus National Australia Bank in 2010 closed the door really on global securities class actions there. If you bought your stock in the UK, for example, in BP, most of your avenues to redress in the USA were closed by that case. So when I'm going to talk about securities class actions, I'm not necessarily talking about global as such. I'm talking about securities class actions more generically. Collective actions would be group actions where there isn't a class action mechanism. So Mr. Merrick, I was really interested to hear what he had to say, and I think he really described what is still a Dickensian system in the UK. I can say that because I've got this accent, so I'm allowed to. Britain's most famous cigar-smoking prime minister once observed that Americans will always do the right thing, only after having tried everything else. They are doing the right thing, generally, Morrison versus National Australia Bank, they're doing the right thing when it comes to securities class actions. And I wonder if it weren't for the knee-jerk, oh, we can't have the American horror experience, if it weren't for that, I think you'd be able to persuade your legislators to adopt a more reasonable approach. In the UK, the system at the moment, which has Section 90 and Section 90A of the Financial Services and Markets Act, in my view, has been foisted upon everybody as a result of a complete misunderstanding of American law. If you look at the background to the legislation, they talk about negligence being sufficient in the USA to ground liability, and that needs to be avoided at all costs. Well, it's just not true. We're talking about fraud cases. There may be cases where there's offerings and negligence is sufficient, just as in the UK. But for a regular securities fraud case, you need to demonstrate fraud. So what are institutions doing? Well, when I first practiced in the United States, institutions were absent from securities litigation. The cases were controlled by high net worth individuals who had close relationships with lawyers. And the way carriage was determined was first to the courthouse. So that meant, in my early practice, we had teams of young, typically guys with skateboards, motorbikes, you name it, and they would race to the courthouse with our filings. And because we were very, very good at it and very, very fast, we built up a practice that carried us through to the next iteration, which was the entry of institutional investors. 1995, the Private Securities Litigation Reform Act was part of Newt Gingrich's contract with America. We called it the Contract on America. And part of the 10 things that they were determined to do was to do away with securities class actions as they were known at the time. And as a result, they decided, we'll put institutions in charge because they won't want to really be involved, and they'll arrive at more sensible results. Which, of course, had us then scouring the country, ultimately the world, to build up an institutional investor practice. And we've done that. Our competitors, of course, have followed suit and done that to a large degree. And as a result, we now monitor the transactions for vast numbers of investors around the world, and we can notify them when there is a fraud that may have impacted them. Now, what sort of investors, what sort of institutional investors would want to get involved in this sort of litigation? It varies wildly. It could be a very small fund that's the captive of an industry player, and they may have very close relationships, similar to what I described before 1995, except it's an institution. It could be CalPERS, huge pension fund, and it could be everything in between. And the importance of entities such as CalPERS, of course, getting involved in this sort of litigation is that it sends a message to other responsible institutions, independent institutions, not captives of law firms, to get involved as well. And that is happening more and more. Yesterday, I'm pleased to say, CalPERS, who we represent, made a motion for lead plaintiff in the Palantir case. Don't know that we'll win the case, but we've alleged that they suffered $55 million in losses, and we hope that that will secure the lead. If you don't know, only in America would this happen. The biggest loser wins. 60 days after the first case is filed, anybody who wants to lead the case has to file their motion, and the judge is obligated to award carriage to the entity that appears to have the largest financial interest in the outcome of the litigation. So, again, who is most likely to have the largest interest in the outcome of litigation? A big institution. So again, all roads lead back ultimately in the biggest cases, typically, to large institutions who've now become involved. With that, I'll hand over, but obviously I'd like to enlarge when we come back, and particularly if there's any questions.
Yeah, I'm definitely going to have some follow-ups on that, but that's a great way to set the stage for you, Pete, and to talk a little bit about when a case settles and how institutional investors get involved in either the notification or claims process.
So obviously, as the administrator, we're the rear, and some may argue literally, of the process. But that said, I think we define institutions probably differently in a practical sense than either the lead plaintiff counsel would or the custodian nominee would. For us, it really is a breadth of people playing different roles in the administration and claims process, right? It's custodians, nominees, it's asset managers, it's law firms representing people and filing on their behalf, it's contingency filers, et cetera. And you have instances where you have a single claim that might touch 3, 4 financial institutions within that singular claim, right, through intermediaries. You have multiple claims filed by multiple institutions, all for the same underlying beneficial owner. So our challenge in every case is to bring all those pieces together. It is typically the largest amount of claims by a long shot come in through the institutional channels. It is certainly the most amount of money, and it is certainly the most risk. And so, we have to spend the proper amount of time to ferret out those claims and those issues that stem from them. But at the end of the day, what we also try and remember is that underneath that, an institution such as CalPERS are people. So, there's an element of justice to what we do as well that I think is quite important. I think from our perspective, the institutional filers institutional participants play a role in 3 pretty critical areas, the first 2 being particularly critical. One is the notice process. So in North America, certainly the notice process hinges heavily on getting names, and addresses that allow us to give notice or allow the custodian's nominees to send the notice themselves to the underlying beneficial owners. So the timing of how that's done, the quality with which it's done, helps people understand their rights, but certainly can potentially impact it in a negative sense if it's delayed. The second element beyond notice, I would argue, is claims filing obviously has a very big connection to institutional filers, right? We see, again, the vast majority of claims that come in our case, certainly the vast amounts of money are coming through institutional filers and or institutional entities that are participating. And these claims reflect the increasing sophistication of transactional instruments. They're complex, they're hard. 3-4 years worth of a class action period, you may have a claim with millions of lines of data, right? How do you make sense of that? What's the documentation that's necessary? How do you get to the underlying beneficial owner, especially through intermediaries, and sometimes there's a lot of opaque information that's provided. And again, that's where I would argue the vast majority of our risk is on a case basis in a securities claim. You could have, I'll just give you a practical example, you could have 2 or 3 different entities file for the same underlying beneficial owner because they all had certain elements and responsibilities during the class period. They all provide you different information using different unique identifiers, different account codes and representations, and our job is to put that all together and make sense of it at the end. And then finally, the last piece is payments, right? They play a pretty critical role in the payment process. I will say, we have, it's not a love-hate relationship, it's a mutual dependency in a lot of ways, but our interests, and I think you guys would agree with this, they don't always align, right? So we have to work together to do the best that we can to make it work for all of the people underneath and make sure the process is as clean, as timely as possible, while also ferreting out all of the pretty complex issues that align underneath. Mm-hmm. I'll turn it over to you.
Yeah, no, that's great, Pete. I'll agree and disagree with your last comment. I think in general we're aligned that we want everyone to get notice and we want everyone to get their fair share of the settlement. But then how that all plays out, definitely there can be tension. So that more good background, Christy. You in your role talk to institutional investors of all types. So the pension funds that Mark talked about and the broker dealers that Pete talked about. And you've got, with all of the new EU regime and the UK regime, you've got new bespoke processes, and it's impacting them differently. What are their biggest concerns and challenges these days? What are you hearing?
Sure. So really great background from both of you, and certainly, like, throughout my career, I've been where you sit, and I've been where you sit, and I agree with everything that you both said. So at Broadridge, what we do is we portfolio monitor for our clients. We have about 950 clients of all shapes and sizes, even a couple of family offices, pension funds, certainly hedge funds, large asset managers, smaller asset managers, strategic asset managers, broker dealers, custodians. And so we are in the field talking to them all the time and sort of hearing, what's on their mind about class actions, sort of what concerns do they have, what sort of decision points do they have to make before they get involved. And just to be clear, most of the customers we're talking to are initially sort of talking about the automated claims, right? The opt-out claims, the traditionally North American claims, although certainly now the opt-out regimes are certainly expanding, and it looks like with the Netherlands and possibly Germany too, and then the competition cases in the UK. But most of the time they start off sort of talking about that. But often, especially with some of the larger customers we have, like custodians, they do have also concerns about the opt-in cases. They're seeing more of these, they're reading more about them, they're seeing that they're large dollar recoveries, and they're realizing they have to bake that into their thinking. And that is it's a different model. So here are the sort of 3 things they ask us about the most, and I would say this is what I probably spend 95% of my time talking to them about. The first question they ask is what are my obligations and responsibilities, right? They want to know kind of out of the gate, what do I have to do here? What should I be doing here? What's everyone else doing here? Is anyone else doing this yet? We don't want to be the first, but we don't want to be the last. That's the first question. I'll talk a little bit more about that in a second. The second question we get a lot is, how do I understand the materiality of the opportunities in the space. How do I wrap my head around that? How do I know what matters and what I should spend time on and what I shouldn't? And then the third question I get, and this comes in various ways, it's articulated in different ways depending on who we're talking to, but how do I participate in the right way without adding a ton of lift on my internal resources and my team? So just to kind of expand on that, as far as obligations, like how do they determine what their obligations are? It definitely varies by the type of the client. We know that certain clients absolutely view it as a fiduciary obligation that they have to their underlying investors or customers, and certainly in the pension fund space, we see that quite often articulated pretty affirmatively. I would also say that RIAs, under the Investment Advisor Act of 1940, with the duty of care that was articulated there, that's another area for that sort of fiduciary duty to play in. And then also with trust banks, where we see a lot of discretion vested within those kinds of entities. And generally, the more the discretion that the advisor is given, the more that they view that they have some sort of official duty here that they need to be doing these things. So certainly there are lots of different sources for these duties to derive from. Some, again, are statutory, some maybe even, from common law development in the US. We have a very rich common law set of case law on fiduciary duties and what that means. And then some are contractual. Some of our clients have really specific things that they've obligated themselves to in their contracts with their customers. So we sort of help them without providing legal advice, because we don't do that. We sort of help them understand how their peers in the industry are evaluating their responsibilities. And very often when they decide they have a responsibility here, it comes from one of those resources. Another thing I want to mention here, it's certainly something we're all talking about a lot. Steve and I were at a conference earlier this week with pension funds in the US. It was a big topic there, and that's ESG. As far as investors go, many of them that we work with view their participation in these cases, even if it's just passive claims filing, as part of their sort of governance component, right? That their participation in these matters can be viewed to drive better corporate governance. I think that's very true with my colleagues who are international, really focusing on those entities. And in the US, I think it's true as well, although I don't know how much you guys are following this, but there's been a bit of a backlash in the US about the ESG focus for investments. It's becoming a very sort of partisan thing, whether that should be part of any of the decision process. But I can tell you that clients do talk to us about that. They think that that's interesting, and sometimes they will derive their set of responsibilities from how they view that governance component. And then also the sort of last thing that they think about, and this is less about a responsibility and more about a business strategy or responsibility, and that is staying competitive. So they want to know, and this is particularly true with broker-dealers, asset managers, hedge funds, what are our peers doing in this space? Do they have asset recovery policies? Are they participating? If so, they want to stay competitive. They want to be able to attract customers. They want to be able to attract advisors. And so then some of our clients find their duty sort of deriving from that more business strategy. As far as like measuring the magnitude, we definitely find that in certain kinds of clients, this is more true, that they have internal teams that have been doing this work. And by and large, almost without exception, for those internal teams, securities class actions participation is a secondary or a tertiary or maybe even further down the road in terms of sort of what their primary responsibilities are supposed to be. I know in the US we had, actually I think this is globally, we've had about 162 claims filing deadlines this year. So if you think about the fact that there were 260 working days this year, that means that these teams are basically more than every day and a half facing a filing deadline. So it's a real lift on them, and they take it very seriously, but it's something that customers are really finding they want to sort of shift, and so they want to know kind of how do we do this the right way. And then finally, I would just say that minimizing the lift on their team. Once the clients sort of say, okay, we should do something here for whatever reason, and look how material the opportunity is financially. They want to know how to do it the right way. Peter and I were talking before the session. The big lift here tends to be in the data area for the clients, and no surprise there. There could be lots of resources for the data. It could be custodian, it could be multiple custodians. I'm in conversations with someone right now that I think has 17 custodians globally. And you know, the sort of the data challenges that go along with that. So I always really recommend, like right up front, that we do the most fulsome data lift that we can right out of the gate, so that everybody's paying sort of right on the front end. Set up those regular, you know, data refreshes as well. And then finally, I would say they ask a lot of questions that really all tie back into this sort of idea of having a really firm, articulated policy in place, right? They don't want to be reacting. They want to know, here's our level of materiality. Beyond this materiality threshold, come and talk to us if there's an opt-in opportunity. Beneath that, don't come to us. We're going to save our team some time. They may have a red line on anonymity. They may not be willing to be sort of a public participant, but willing to be a behind-the-scenes participant. So we really do spend a lot of time answering those kind of questions, particularly on the opt-in cases where we know that there are other risks that may not be so true in the US, including things like loser pays provisions, et cetera. So that's a really big, overarching sort of review of what the questions are that we get most of the time and sort of how they answer those questions.
That's great. That's great. Thanks, Christy. I think we have about 10 minutes, and I've got questions for each of you, but I thought before I got to them, we'd just give the audience a chance in case there were any questions as a follow-up or other topics maybe that we didn't address but hit these issues tangentially.
The prior panels won't be offended.
All right, well, I'll start. So, Mark, you talked about the Palantir case, and I've got a couple of shares if you need to add them to CalPERS in your motion. But really what I wanted to hear about is, how do your clients think about when they should be thinking about being lead plaintiff versus opting out and having a direct participation versus being passive and waiting for there to be a settlement?
Yeah. So our firm and our lawyers are pretty mission-driven. Obviously, part of the mission is to make money, but the mission that people identify with at the firm is taking on big corporate wrongdoers and balancing, at least providing some balance. So incredibly mission-driven, and we take that message to our clients, and we get that from our clients. So many of our clients, for example, in the UK, are local government pension funds who have signed on to the stewardship code. And many of them take that code very, very seriously, so seriously that some of them have built securities litigation into their protocols and cited the stewardship code as one of the reasons. In the US, again, public pension funds, more than private pension funds, tend to view this as a service that they should step up. Let's face it, if no one stepped up, there wouldn't be anything like the recoveries that there are, and they are billions of dollars every year in the US. And some adopt a system where we'll show up, we'll do one case, we won't do more than one at a time, but if the case is compelling, if our losses meet a threshold, then yeah, we'll do the case. Many will take our monitoring services and never file a case, and that's fine. At least they're able to make informed decisions, even if that decision routinely is thanks but no thanks.
Mm-hmm. That's great.
I think one interesting thing, and Christy raised this a little bit on the PSLRA and sophisticated entities driving the process, is the opportunity to actually not just drive to a settlement, but drive to true corporate governance changes. True. So the PSLRA had a very positive effect in that manner that we've seen in some settlements, right? Not just the actual redress that goes to the claimants, but also a board change. Hey, we're going to, you have to put in 3 independent board members. You have to make these other changes. Obviously, we as an administrator have nothing to do with those elements, but we see them in some of the settlement agreements. I think it's an interesting and positive effect that came out of the changes in the law.
My partners would be angry with me if I didn't point out that we've pioneered many of those changes over the last 20 years, and they are important. Often it's separating chairman and CEO, it's rotating auditors, it's installing an ethics officer, you name it, often to try and address or prevent recidivism. So yeah, it's you can't win the governance at a trial. So it's a delicate thing. You have the leverage, and your job is to get your clients, the class, the most money you possibly can. You shouldn't be surrendering money for governance. But if you can work it, that you're maximizing the recovery and insisting on governance reforms, that is obviously a sweet spot.
Yeah, to your point, and Pete's, I just saw a chart the other day. It was done by one of the economics firms. The average settlement value is way higher when you've got an institutional investor serving as lead plaintiff than when you have individuals. So
Absolutely.
that goes along with the governance as well. Pete, you handle cases from back to Enron to some of the more recent ones you mentioned, like Fortis and Steinhoff. And I'm wondering, as we've got these emerging legal landscapes, what are the differences you're seeing in some of the claims processes between traditional U.S. versus some of these newer large settlements here?
Right. I hesitate to make too big a leap just because I think the regime here is still playing out, and in the States and Canada we have a pretty mature process. But a couple things. One is, everything or almost everything's held in street name in the United States. And certainly in Fortis, there was a very significant registry of retail shareholders. And so we're interacting with them directly at different phases in a way perhaps that we didn't do in the United States. I think the other thing is, in both Fortis and Steinhoff, there are foundations that oversee the process. And it's actually been quite good for us in a lot of ways because it forces you to evaluate and rethink about what you're doing and have very sophisticated people looking at things with fresh eyes, which can be painful at times, to be frank, but I think has been very good for us in terms of how we think about things. I think the other thing that struck me is the composition of the foundation is comprised of active claimant groups, the defendant, and then a neutral. And it's very different than having a singular class counsel or co-lead counsel oversee a case where they're kind of view everybody as their class member. In certain instances, the ACGs representing different shareholder groups may see things differently relative to the needs of their group, and I think it actually at some levels it may be a healthy tension. But it was interesting to play through that and try and understand it, and I think we're still going through that. But you don't have experience until you have experiences. So those were the most immediate differences. I think the other thing is everything is electronic. Obviously we have a very significant electronic process in the United States, especially with the institutional process. But payments are all electronic. The process is all electronic. I think there's not a generation ahead, but a few years ahead of where we are in that aspect. So those have been the biggest ones. But like I said, I think getting fresh eyes and very sophisticated, thoughtful people looking at what you do and helping you think through it is a good thing.
Great, thanks. And you mentioned nominees and retail shareholders. That sort of, I think, leads me to my last question so that we can stay on target maybe a couple minutes back. Christy, earlier Pete was talking about the notice process versus claims. I know you talk to broker-dealers, all the time about these issues, and I know there's been a kind of a material shift over the last few years. Can you share a little bit of your experience with that?
Sure. So we have Broadridge is a global fintech, and there's really great connectivity with all of the broker-dealers around the world for different kinds of services. Broadridge is also an investor communications company, and so very facile and lots of data for other services, statement renditions and things like that for digital communications and hard copy communications with underlying retail and wealth investors at broker-dealers. So to the point that these guys have been making, in the US and in certain other cases too, the court will order broker-dealers and third-party nominees who are facilitating trades in the stock at issue when there's a settlement to make sure that their underlying customers who engaged in those trades are made aware of the settlement. And you guys know what these notices look like. They typically can be 12, 18, 24 pages. I'm sure we've all seen ones that are far in excess of that. But they're big legal documents, they're big legal packets. I used to draft those when I first started practicing, and that was super fun, as well as driving to the courthouse with no skateboard to file those first cases. But in any event, so broker-dealers have for decades understood that they had to make sure the notices got out. So they would cooperate with the claims administrators, Peter and his firm and others, to make sure the notices get out in a timely fashion so that their underlying customers can file. As I mentioned earlier, at Broadridge being a communications company for broker-dealers, Broadridge actually does a lot of that for broker-dealers. A pretty significant majority of the broker-dealers in the U.S. use Broadridge to sort of send out those notices. So it's something that we're already sort of doing for them. But because of the things I mentioned earlier, all the developments we're seeing, the expansion of the opt-in cases, frankly, their competitors starting to think about filing claims, the broker-dealers are talking to us a lot more about filing claims. And in fact, we've had, I think, it's north of 15 broker-dealers that have signed with us for filing in the last few years, and a lot of those have been in the last couple of years. And they sort of take that same analysis I talked about, which is, okay, so we're doing this already. We have an obligation to get the notices out, but do we have either an obligation or a desire to facilitate filings on behalf of our underlying customers? And then a lot of the conversations take place around sort of how do we do that in a really nice, compliant way? How do we talk to our customers about the fact that we're doing this now? What does it look like? How do we keep them informed? How do we, piggyback off of the sort of notice we were providing them before and now expand that to filing? So it's certainly been a big shift. I would say it's one of the more material shifts that we've seen when we're out talking about class actions to broker-dealers. I think it's a great shift. I think that in the broker-dealer space, we all know with the typical investor, we just don't see them investing the time to actually fill out the claim forms, depending on sort of what their actual loss might be in a case. And an enterprise approach for retail and wealth investors to filing can be a really valuable thing to really increase the participation of the individual investor, which is, at a certain volume going to have just as much impact on the overall settlement as some of these larger institutional investors that we're talking about. It's an interesting area. I'm happy to answer questions about that too, by the way, because I know it's kind of new and it does implicate a whole lot of different things.
Two things, I think, just in response to that. One is, I think the other ancillary piece of that is you're seeing movement on the security side away from the paper notice to postcards and emails. Mm-hmm. That's one piece. The other piece, you guys do a fantastic job, but there were a couple class action settlements several years ago regarding people who weren't sending their underlying owners notice, institutions, and they ended up getting sued and had class action settlements actually as a result of their failure to provide timely notice or notice at all to the people who thereby lost the right to participate and potentially gain redress from their settlements.
Yep. Yeah. That was definitely an interesting development. So I'm getting the high sign. We've got about 2 minutes left if there are any questions from the audience. If not, we'll give those couple of minutes back. I know we're running a little bit late, so. Good. Well, thank you all. I thought that was an interesting panel interaction, and thank you all for having us.